Now, my first point when I opened last time, without the benefit of replies from R3 and R4, which we received yesterday, etc. The point I had made was that 17A needs prior approval. A, let me break it down point-wise. B, prior approval is mandatory under your lordship's established several judgments. And C, the textual ingredients of 17A, leave aside anything else, even the textual ingredients of 17A were ex facie not satisfied, and yet the governor has granted sanction. Two of the textual ingredients of 17A not satisfied were only on the application of an investigating agency / policeman. That is one. There is no application by any investigating agency or policeman in the present case. And that, I submit, is a condition precedent of a mandatory provision of the textual language. And the second was that it must relate to a decision taken or a recommendation made by a public servant. Now, these two ingredients follow from 17A. Your lordship saw it last time with me.
Yes.
No police officer shall conduct any inquiry, open with police officer, or inquiry or investigation into any alleged offence alleged to have been committed, where the alleged offence is relatable to any recommendation made or decision taken by such public servant. So, opening is police officer or investigating agency, and recommendation made or decision taken is the second ingredient. Both are not only admittedly not satisfied, not invoked, cannot be satisfied, cannot be invoked. They don't arise. And the public servant here has neither made any decision nor any recommendation in any capacity as CM or Deputy CM, etc. This is my first point.
Right.
Your lordship would see my law index alone. I'm surprised, all the cases, this is worse than carrying coal to Dhanbad. All the 3 judgments I've got, I did not realize it till I saw them.
Yes.
Are, I believe, authored by your lordship. So I'm not going to actually carry coal to Dhanbad. But your lordship see the law index. There are 3 judgments cited by me in the opening.
Yes.
The first proposition is Ashok versus Lokayukt. Second is Yashwant Sinha versus, not that.
That's Supreme Court.
That's the third one was Shirupa. And most important, fourth one, Praveen Kumar.
Fourth one was the first one. Rendered.
That's right. That's right.
Yes.
This put wrong in the serial. Now, these ballots make it clear that this is mandatory, this is clearly necessary, and that it has these ingredients. Well, the relevant para of this Praveen Kumar is para 14 to 16.
That is with regard to application of mind.
Mind.
Yes.
And it's at 138. Woodbine was want to read it. I don't think it's necessary. The lordship has seen that it's.
Yes.
These are not altered, appealed, challenged in terms of variation. I don't know if the challenge or not.
These judgments have become final.
Final. But certainly not varied in any manner. I don't know if they're lying in some challenge here or there, but they're not varied in any manner. The Sirupa is para 23 to 28.
Yes.
And that starts in my compilation at 106.
Yes.
And the third one is Ashok, para 15, which starts at page 5 of the compilation. So, first point, Balats, the language history. Second point, the 3 cases. And 2 additional points before I come to what has happened now, which is very, very interesting, virtually almost comic. The circular at 260 of the paper book, which is the circular of the Honorable High Court of Karnataka at 260.
That is implementing Ashok.
So that your lordship has noted. And then, Malaz, there is a SOP, a procedure
of the Government of India.
Of the Government of India, dated 3/9/21 at page 703.
Yes.
Which my lord saw with me last time, para 2 and 3.
Yes.
These are the 5 points I made in the opening, QA 17A. Now, Malaz, there is something interesting, a lot of interesting developments on 17A alone. We stick to 17A for the time being. And your lordship will note those developments. Malaz, one of the, I would say, the principal complainant, if I may give him that special post and position, even amongst complainants, there should be an hierarchy. The principal complainant has now filed a reply saying,
which respondent are you?
R3.
Who appears for R3? Yes. R3.
Reply, which I'll be presently reading in a minute, says variously, there is itself is a bit of a fudge, but and I'll take it both ways. He says no 17A is required. And then he adds 1 or 2 places, just a word. He says unconditionally no 17A is required. I'll read that verse in a minute. And then he says not required at this stage. So he takes both, please.
Objections. List of citations.
I will take it either way.
Yes, sir.
If your lordship will turn to that verse in particular at page 60 and 61, and I'll take the liberty of reading this a little slowly. para 20 at 60.
Yes, sir.
In the private complaint filed before the special court, the stage of court taking cognizance has not yet reached. And R3 in his private complaint has only sought for reference to the concerned investigation officer for investigation under 156(3) of the CRPC in accordance with law. Therefore, the question of taking cognizance at the current juncture does not arise before the special court. It is submitted that on this ground also, R3 need not obtain sanctioned as envisaged and 218. Currently, the private complaint, which is an unnumbered one, is posted for hearing before the special court. Nevertheless, the R3 applied for sanction. Mark this word. Nevertheless, R3 applied for sanction to the governor in adherence and compliance of the honorable judgment in Ashok, as the same is currently the law of the land, as an adherence exercise and a procedural formality, not any substantive requirement, a procedural formality, pursuant to the circular issued on 4th of July. Now read the next 4 lines.
Yes.
Although the order of sanction from the competent authority under 17A is not required for the instant case, and the sanction under 218 is not mandated at this juncture. Now, Milits, I have 3 or 4 points here. And I don't want to sound facetious. The whole of writ should be allowed, or he should withdraw his complaint, rendering the sanction complete waste of time, and the governor should first impose costs on him. And then later on, your lordship should impose costs on him. Your lordship, why? I'm not making a facetious comment. Now, this person, your lordship, read his pleading. It's on solemn affidavit filed in the court, given to us yesterday, day before. That's why I said, were it not serious for me, it would be comic. This person, Milits, like Alice in Wonderland, applies to the Lokayukt. The same person. Please turn to Milits, to the governor.
Yes.
At page 48. Page
Was it
48.
applied before the Lokayukt also?
Also, the Lokayukt.
Complaints with Priyanka Srivatsal's case.
I'll do that
Complaint
also.
was lodged.
First, come to the governor.
Complaint was.
Complaint was lodged.
Apparently, Milits, the entire machinery must waste time on his vexatious complaints, which he says, I don't need to make a complaint application. Why should I trouble the Honorable Lokayukt and Honorable Governor? Come to Milits, page 43 first. Sorry, 48 first.
Of the objections?
Of the Milits, of the petition, of the paper book. Now, your lordship just read his affidavit. Now read this. His Excellency, the Honorable Governor, on 26th of July 2004, first line, request for sanction for prosecution of Mr. Siddaramaiah, etc., etc. And read the 4th line, under 17A and 19. And 218 also, Milits.
Yes.
Also, Milits, end this at 69. Which is the last para. Wherefore, it is requested from your good office to directly grant sanction for the prosecution of Siddaramaiah.
Yes. What is this? Illegally gaining rupees 55 crores, is it?
Where is it?
No, the complaint is about that.
Please.
55
Yes,
crores.
yes.
Application for sanction.
He makes a quantification of this whole issue and says this is illegal. At the moment, we are on his affidavit and we are on this. Right? Now, again, this is not just a single Milits swallow in the summer, not a single bout of madness. It is a consistency. Page 200. Same volume. Information of so-and-so, so-and-so. Where is it? Why did you give me local? Does it have?
Yes.
Does it mention sanctions? You have to give me only when it's sanctioned. Now, Milits, here he has made a complaint where he does not say anything about 17A.
No, this is only a complaint.
Complaint, correct.
It need not comply with 17A in this.
Right. No, I'm just saying, Milits, he's come all this way to the governor, etc. He makes no mention about anything.
Yes, yes.
Now,
This is earlier to the governor's.
that's right. That's right. Now, Milits, Milits, put it like this. He has made a complaint. He seeks sanction. Governor grants sanction. It's not a suo motu governor action. The governor action is based on on XYZ's complaint. That complainant says not necessary. Well, then, Milits, obviously, since he will not withdraw it, your lordship should, Milits, treat that application for sanction as non-existent on this basis alone, on the counter affidavit. And therefore, the basis and the foundation of sanction goes. We are not here to answer academic questions We are not here to balance the entire foundation of the sanction order goes. And this is not balance. This is balance. A person who is facing this, like me, the petitioner, has every right to say this is absolutely a farce. I didn't mean it lightly when I said the governor should, before sanctioning prosecution against me, impose costs against him. If he has the power, certainly your lordship has the power. I don't know if the governor has power to impose costs. So this is the short point on which on the second aspect of 17A, and it's a full point, but I submit with respect that this cannot be just that you come to system, you set a whole thing in motion, and then you say not required at all. Well, then you have to be straight in your stand. You take your chances. What is the problem? You go ahead, prosecute. We'll see whether sanction is required or not. You can't have it both ways. You get a sanction. When I come to court, you tell the court in the counter affidavit, I didn't require a sanction.
Don't you mean to say that they can proceed with it without sanction?
They should. They should, Balas. They should have the courage of their convictions. I'm not saying anything. I'm only defending. Imagine, Balas, that's why we say, Balas, that's why. No, there's another facet to it. In practical, not in law also, Balas. People like the governor should be restrained. That's what happens when anybody walking about the path makes an application. Well, should not the governor have said that you don't require sanction? If you applied your mind. I'm not saying he would have or should have. Well, if anybody on the road comes to him and says, give me sanction, he's so eager to give the sanction, the man himself says, no, I don't need sanction.
No, but approval under 17A is not sought prior to all actions. It is when the court proceedings were on, I guess, after the complaint being before the court.
Yes.
The approval is sought at the hands of the governor, not before that.
No, it's
When was the complaint registered?
First, the sanction was sought.
Amal complaint registered. All right.
Right at the threshold. And your lordship, 3 mandatory judgments are prior sanction. So, Malas, this is Malas very serious. He's playing ducks and drakes, A, with the governor, who has actually granted his prayer, and B, with the court. And Malas, the only legal consequence of this is, of course, I'm not saying that he's going to withdraw, should be his withdrawal on the basis of his affidavit. He can't, Malas, the affidavit prevails. Perjury prevails on an affidavit. He can't be perjuring himself by filing the affidavit before your lordships. So on that affidavit, he must withdraw. Otherwise, your lordship should, Malas, treat that as non-est. The moment it becomes non-est, the sanction goes. So that's the ground for the sanction to go. It's not a suo motu sanction.
No, it's not.
Now, Malas. Now, the other person, like Alice in Wonderland, gets curiouser and curiouser. That is the phrase used in that book. It's quite remarkable what happens in the other case. That is Mr. 4, R4. Well, he has got sanction also from the governor. Your lordship has got an order. The final order mentions, suddenly, notice came to me only for R3. That's why I mentioned this.
A particular
4, 5
paragraph
also.
mentions these two as well.
These two also. So the governor is purportedly applying might to 4 and 5 also. But it now transpires that R4 never sought sanction. The other fellow says, I need not have sought sanction, but I did. I hope I'm clear. If you actually examine R4's complaint, which has now come to me, and I'm going to ask my learned friends better equipped in Karnataka to read it all.
Maybe some restraint, my lord, on
Wait,
usage
wait.
of words.
When sin is submitted, wait.
I'm going to ask you to read it.
Anything I'll ask you.
No, my lord. On usage of words, my lord. There may be some restraint.
About
my lord.
what?
Some fellow, Alice in the
that-
Wonderland.
yes.
My lord,
Sorry.
it's not, my lord. There's no impediment for me to use such words.
Yes.
But protecting the sanctity of this honorable
Yes,
court is utmost important.
If
The-
literature of Alice in Wonderland
It's not a revenue
standards
code,
are
my lord.
objectionable,
No,
unparliamentary words, I plead
it's
guilty,
like-
Willis. I
You may,
plead
you
guilty.
may address them as respondents, that's all. Yes.
Now, Willis, we are in a case where the first person says that I applied for sanction, but I need not have applied, which is sufficient to allow the sanction to fall.
All right.
The second person says, I never applied for sanction. Then how did the governor grant on
But
what?
he has not applied. That's a fact.
That's fact. Now, just see that. Just see that at 376, his application. It's quite remarkable. 5th of July,
Whose
2020,
application?
R4s. To the governor, which is now, well, we have got only well, with this reply,
76 of what?
376 of R4's objection.
R4 objections, madam. R4 objections.
Now, well, it's just this much shows I'm not interested in R4, who have not even filed. It shows complete non-application of mind of R2. Complete, total and absolute on that short ground, the sanction must go.
One clarification. No, 1 minute. One clarification. Here, there is, he is not seeking sanction at all here. He's only asking the matter to be referred for investigation to the hands of the CBI. And inter alia, he says that he should step down.
Correct, absolutely.
So this is not a question of sanction at all.
Correct. He goes to the governor passes an order on this. Sends me a show cause based on this.
No, show cause notice is not issued on this.
No.
Not on
No
this.
show cause notice is
Not
issued on this.
Then, Malas, the order says I'm.
A paragraph
That's
refers
right.
to this.
That's right.
But no show cause notice is issued to you on this.
Point out one of facts. This morning, along with a memo, we have filed a communication dated 31st of July 2024, which we have submitted, my lord, to the honorable governor, which seeks for sanction. Kindly see that. memo.
When was that given?
31st of July. This is after this letter, another communication. That is what I want to point. So, my lord, to say
Governor refers to this, you mean?
by date, that governor, my lord, does not refer to it by date, but to say that no sanction at all was.
Why you did not file this along with the statement of objection?
No, Malas, I'm very happy. Please let them. Malas,